So, dear colleagues, welcome back. It's the fourth session, and we have again several parts to be addressed. And I was even too quick, but we will start with a special subject matters or substance driving procedure. And the segment will be presented by Wannes van den Busche from Ghent University, who has in the chapter addressed consumer disputes. But Guanling Chen from Taipei is also here, and I asked her to join because she has already finished and handed in a very excellent chapter on labor proceedings. But you get immediately the floor once.
Thank you, Professor Hess, and thank you to you and the other editors for inviting us to this project. I can only second what has already been said. It were 4 inspiring years working together on this. So our topic, special subject matters, means that in the field of civil procedure, a number of subject matters are commonly described as special. Some legal proceedings are classified in that way because they have a long tradition of having specific procedural rules. These include family proceedings, succession proceedings, commercial proceedings, labor law proceedings. Additionally, new types of litigation have emerged whose importance and prevalence have only increased. Examples on this you could also see on my slide: private competition law proceedings, data protection proceedings, intellectual property proceedings, consumer proceedings, and so on. So you could already assume that within our segment it was not possible to cover everything, especially as we took a vertical approach that we divided into different special subject matters. So we had to make choices. We also lost some contributors along the way, but only as regards the project, of course. But what is the current state of affairs? We have an introductory chapter by our former coordinator, Catherine Pichet. The first chapter that is already on the platform is Labor Law Proceedings by Guanling Chen. Soon or very soon should follow environmental proceedings by my co-coordinator, Maria José Azarbo, private competition law proceedings by Lena Hornkohl, and competition protection proceedings by myself and my colleague Piet Taalman. And also foreseen are chapters on family litigation by Volker Lipp and commercial proceedings by Stephanie Law. Now, in the next 13 or 14 minutes, I would like to reflect a bit on not something that I have written myself, but which is based on an analysis of the chapters that have already been submitted and the introductory chapter by Catherine. So I would like to highlight some common characteristics of all special subject matters, reflect a bit on the broader framework, and draw your attention to key aspects of the respective chapters that the team members have themselves considered as their highlights, and then conclude with some further questions that after 4 years working on this project, we still have no answer on. So I mainly base myself on the input I received, and I would like to thank Guanling, Maria José, and Lena. So, as mentioned earlier, in the field of civil procedure, there are some subject matters commonly described as special. And there's a strong common thread between these special matters in an abstract sense. They all pursue specific needs, values, policy objectives that can be proved difficult to meet effectively through the general rules of civil procedure. As Margaret formulated so beautifully yesterday, it's not necessarily about the individual resolution of disputes, but about shaping norms in society. And then if you look at this, we identified that special subject matters often involve disputes between so-called unequal or unequal litigants. In such instances, the strict laissez-faire approach, as you could say, of providing the parties with the same procedural rights, no matter of their personal differences, might be not appropriate. Labor law disputes often involve an economically disadvantaged employee vis-à-vis an advantaged employer, making substantial equality essential. Consumer cases, as well as private actions in competition law, involve or reveal a power imbalance between consumers, small enterprises against big businesses. Environmental litigation focuses on cases where nature, even, or at least an NGO who acts on behalf of the nature, stands against a sophisticated polluter. And then, in addition, you also have special subject matters where there's not necessarily such an unequal relationship. Both litigants are on equal footing, such as two large companies in commercial proceedings, or can be two partners going through a separation. In these instances, it's really the nature of the matter itself that necessitates special measures. For example, in commercial proceedings, the need for speed and flexibility that is paramount in business relationship, while in family proceedings, protecting the intimate relationships is crucial. Here, substance really drives procedures. And of course, you can also have a situation where both actors come into play. For example, a divorce case in which you have two partners on unequal footing, or child protection cases. So that brings me to two common threads in our segment, and the first one is like this interaction, and I also already presented it in March, between two competing principles: the transsubstantivity idea, which pushes the design of rules toward a generic and content indifferent form, and on the other hand, substance specificity, which points towards the need to tailor procedural rules to a specific type of litigation. And here at first sight, we can observe a common civil law divide, you could say. The idea of having substance specificity is much more prevalent in the civil law tradition. Historically and currently, there is a strong tendency to establish specialized courts, specialized rules of procedure, specialized rules of evidence, specific procedural devices that are limited to a single area of law. In contrast, the common law tradition appears to favor a more generic procedural approach that applies across various branches of law. And then two examples, or the two most obvious examples. The first one I derive from Quan Ling's chapter, Specialized Courts. In the field of labor litigation, many European countries, Germany, France, and Belgium, have specialized labor courts. Similarly, East Asian countries, including Taiwan and Japan, have specialized labor divisions or tribunals within ordinary courts, influenced by historical and cultural factors and adaptations from German law. In contrast, North America uses ordinary civil courts for labor litigation, similar to other civil cases. Same principle, for example, for a topic that was already addressed earlier this morning, collective actions. Leading example is France, which has so far, if I understood, group actions in consumer and competition cases with a framework since 2014, and then another framework since 2016 for a limited number of other disputes before both judicial and administrative courts, and again limited to certain fields of law: data protection, environmental and health, and help me, anti-discrimination. And similarly, that's also an approach you can see from the EU due to its competences that are more sectorized, that they install collective action mechanism in consumers. They have specific provisions in the GDPR, in the Equal Pay Directive, and so forth. By way of contrast, US class action, Rule 23 is used for a variety of claims: civil rights, mass tort, consumer protection, and the same goes for the Canadian system. However, when we delved deeper into this, we still believe that this common civil law divide can be nuanced, and that even, for example, in the United States, you could find examples where there is still some parts limited to certain fields of law, albeit it is not codified specifically. For example, again, drawn from Quan Ling's chapter, specialized labor courts, even in countries like United States and Canada, there are specialized mechanisms outside the court system for resolving labor disputes. For example, it is mandatory to file a complaint with the Equal Employment Opportunity Commission, which is an administrative agency, before going to court. So here, although the court system is the same, you have a pre-stage in which you have to go to an administrative commission. Same goes for collective actions. Even in the United States, measures have been taken within the general class action regime that specifically and almost uniquely benefit consumers. For example, the Class Action Fairness Act, limiting amongst other coupon settlements, is often referred to as a consumer class action bill of rights, so something that is specifically focused on consumers. However, we also learned that the opposite is true, so that you have to look behind also just statutory rules, where initially you would expect substance specificity. The scope is broader. In Brazil, the class action is included in the Code of Consumer Protection and Defense, so you would assume that it's limited to that, but in conjunction with the Public Interest Civil Action Act, it applies to all kinds of homogeneous individual rights, so it's not limited to consumers. And this brings me to the next point. Again, two ways to handle substance-specific concerns: ex ante, by establishing tailored procedural rules; ex post, through judicial discretion. And again, you could see from a civil law tradition, there's more a habit of establishing all kinds of specific procedural rules. For example, for evidence, if you would look in our chapters, we have in every specific chapter examples where you have in a code for consumers or in the Act on Private Enforcement of Competition specific rules shifting the burden of proof. Brings me to the following. What were the common topics that initially we had a longer list, but then along the way it changed a little bit, and what is present in every chapter, those ones who are still under construction and the ones which have been submitted, these topics. So these are some common topics to all special subject matters. I already addressed specialized courts, also closely linked. For example, for consumer protection, if you look at specialized courts, you have very few in the world. But then if you look a bit further away, you have small claim courts, which are almost exclusively dealing with consumer disputes. In the EU, you have a whole network of ADR bodies which were established not as a substitute to courts, but they have somehow an equivalent function as consumer courts, although they do not qualify as such. Also, standing and the idea of collective redress is present in almost each chapter, again, due to the idea, this inequality between parties that should be overcome. And how do we do this? Well, by giving other entities possibility to act on behalf of the harmed parties. Also, two that I still want to draw your attention to is this relationship with substantive law, which is in general procedure, it's more clear. You have a code of civil procedure and you have a civil code or another legislative instrument. In special subject matters, it's often much more intertwined, where you have like a code of consumer defense in which has also procedural law rules, which has a class action regime, which has special rules on the burden of proof. Maria Jose also wrote about the Civil Action Act that is present in some South American countries, and in which you can discuss is the substantive law because the act itself gives rights, but it also has some procedural angles. Also, in most, but not in all, the promotion of ADR is present. And for some, it makes perfectly sense. For example, again, in labor proceedings, where you have this idea of the harmonious relationship, if if the work still continues, if the parties are still in a further relationship. For family law, the same goes as well. You want to still keep harmony within that family. And then another field in which we have a huge push towards ADR is consumer protection. And that's a bit odd if you put them next to each other, because there is no harmonious relationship that should be strived for between a consumer and a company. So there are other factors driving this promotion of ADR in the EU. I think trying to offer effective solution, and also a bit, I think, to unburden the civil justice system, whereas in the US you read that there's a perception that ADR amounts to a defendant-driven privatization of justice, potentially diverting consumers away from traditional litigation. So if you put all those special subject matters on one line, you can sometimes just like highlight some aspects which are not easy to explain. Next point. In the invitation for this conference, or specifically to the speakers, I read that the speakers will present the highlights of their team's comparative procedural law research in their respective fields. So we have approached it a little bit differently, but I nevertheless asked my team members to send me what each of them considered to be the highlight of their respective chapter. And here you could see the overview. Maria Jose, for example, opts for her section 2, flexibility in the opening of environmental proceedings, in which she differentiates rights and interests at stake, types of actions and standing to sue. And she especially appreciates the innovative notion that nature can possess rights. However, she acknowledges that the practical necessity of having a representative personify and advocate for these rights in legal proceedings. So she considers this as her highlight. Guan Ling suggests the overview of labor proceedings in judicial system, because this part is really an example of the different dimensions that have been brought to light in the comparative study. Within her chapter on private competition law proceedings, Lena considers the interaction between public and private enforcement in section 5 as the highlight. And for consumer protection proceedings, Pete and I would choose for section 2 key aspects, because in this section we really look at what distinguishes consumer protection from other areas of law, and we hypothesize a bit of what could explain this. So let me conclude with a few questions potentially for discussion, to which we still, or at least I, have no answers after 4 years of working in this segment. The first goes back to my first slide. So I give you an overview of all different special subject matters. So the question then arises, what kind of disputes are still behind? Which are then no special subject matters? Are these contract disputes, tort disputes, property, or do they also have own dynamics and own dimensions? Secondly, I think especially for this emerging field of law, is there always a need for a special procedure? Because sometimes it's very easily accepted, yeah, we should introduce this and we should introduce special rules. But on the other hand, and then I'm looking from my chapter on consumer protection, you have a whole bench of substantive consumer protection rules and much less procedural rules that are specifically designed for consumers. Should there be a ratio between those them? So should we give even more special procedural rules a chance? To the extent, and that's my last question, that we may even wonder to abolish the general rules of civil procedure and instead add a procedural section to each substantive law and code. But that also then calls into question our role as civil procedural scholars. So that's maybe one step too far. So I hope I respected my time, and I'm very curious to hear your thoughts. Of course, we haven't written everything, so it was a bit an overview of also our colleagues. But in any case, thank you for your attention.
Thank you very much, Wannes, and my thanks go to the whole team. This is a very impressive work you have done, and one idea which came already into my mind and you raised the question is, we started 5 years ago by trying to find these special areas where we have special procedures. Do we have now additional ones? And I will just directly go to the point. We are in Luxembourg. The Court of Justice is dealing with data protection every day, every day, every day. So data subjects, data protection, is this the next area where we have?
Yeah. And also, like yesterday, you mentioned the anti-SLAPP directive. Is it a special subject matter, or is it more a special form of procedure, or is it something that combines special forms of procedure? So these are two that I think are worth considering. But you refer to the example. It's indeed like the EU, and then another one, but that's partly covered by Maria Jose last week, the corporate sustainable diligence, due diligence directive was accepted, and again it has some specific procedural rules on production of evidence on costs, which again deviate from other EU instruments. So I think in the EU it's also due to the structure of this instance. But I think indeed in the coming next years there will be new special subject matters that currently we do not think of.
Mm-hmm. The floor is of course open for questions and remarks, but one point you had was you were asking, do we need still one codification as we have so many special procedures? And I would be very much against this kind of fragmentation. So just look at Germany. Maybe I'm a little bit unfair because I'm German, but all the modernization of civil procedure regarding provision of information, etc., has been dealt in special provisions somewhere outside of the Code of Civil Procedure. Mm-hmm. And this is a very bad development because modernization needs to be made also in the core procedure law. One cannot say that the core provisions that were renovated shortly after the millennium have been interpreted by the courts in a way that corresponds fully to those developments. So I would rather go for a reinforcement of the general codes of civil procedure and for a better integration of these new procedures, and always for a reflection whether we should enlarge these ideas. They are being enlarged across the different sectorial parts of European law nevertheless. Yeah.
Thank you very much for this very interesting presentation. I'm very curious about what you could find out about insolvency proceedings. Interestingly, I mean, they're very separate issues compared to ordinary civil proceedings, but recently they civil procedure borrow from insolvency law the lodging of claim mechanism to collective redress. Maybe this was an interesting feature, or any other feature you could mention. Thank you.
Yeah, indeed, insolvency proceedings, but I can exonerate myself. It was in the project description that was prepared by the editors. Insolvency will not be covered. So for this we didn't have actually a discussion. Maybe there's another project planned specifically on insolvency.
Bad question.
And this night with CPLJ.
Yeah. But indeed you see this interrelation between these fields. But I'm also I'm on your side, that because I say we have a lot of special rules, but for example on appeal, I think that's like a remedy that hasn't been, as far as I've read, the ones which have been submitted, organized at a subject matter level. It's always like specific fields of aspects of the law of civil procedure that stand out, and some that are not covered or not being told of.
Yeah.
I don't know if it happens in many countries, but I think it may be the case. The problem is sometimes it happens in Latin America many times. We don't define what is the difference that makes the difference. that makes a subject matter different. So we say, well, if the difference is the inequality of the parties, maybe it's reasonable to modify some rules burdening the parties on collaboration and burden of proof, etc. But the specialists on these matters are legislates about who regulates about these proceedings. So they make a whole proceeding with pleadings, evidence, appeals, and all kinds of things that don't have any justification. So it would be a very interesting point on your group to say, well, if the difference is inequality of parties, this difference may be addressed in this, and this matter. If the difference is another thing, like family or, well, the difference is, but you don't have to modify pleading rules or appeal rules and etc. etc. We have to maybe concentrate on the reasons of the deviations and ask for remedies for that special reasoning.
That's a very good suggestion for segment 13.0. But I agree, and that's also like this balance between us as academics looking at this and just like a lawmaker wants to get things done and they don't care about having a coherent civil procedural system. However, what you see, but then I look again from my country, we have a constitutional court which can find discrimination also in procedural law, that similar categories cannot profit from similar rights. So in that way, the principle of equality, when it's a constitutional criterion for a constitutional court, it makes an argument to indeed say, like, to bring some coherence between those different types.
Yes.
I was just thinking with regard to insolvency, it's the point that insolvency.
Would you stand up? And you can.
I was just thinking with regard to insolvency, it's the point of insolvency that it's not necessarily a special subject matter as such, but rather that it's interconnected with another field, with enforcement. Because ultimately, insolvency, if you collect, is the collective sale of all the assets of the creditor in order to satisfy the claim, while enforcement can be the individual satisfaction, but ultimately through the same methods. So if you set it next to family proceedings or civil proceedings, I think that's what distinguishes insolvency perhaps from the rest, is its connection ultimately to enforcement.
Well, we discussed among the editors insolvency, of course. This is why it was excluded there, because we thought it would finally be a specific segment. And then it would also be maybe a little more separated from the other segments we are dealing with, because these collective proceedings are quite different. So, but nevertheless, one might consider including them at the next stage. Any further remarks? So I think this was a very interesting segment. You have found some cross-cutting ideas. Specialization is a huge topic. Thanks again. And I would like to invite the enforcement team. Okay.
We should have some slides.
Yes. Some slides will certainly be available.
Just click. Yes.
We have slides. Marvelous. Thank you. So thank you very much. Just to introduce the enforcement team. And I know Masahisa is here. I saw him a minute ago. And Rudy is here. Unfortunately, Alvaro couldn't be here, but is, I think, online.
Yes, you woke up at 3:30 this morning. That's what it told me. So I hope it's worth its rude awakening.
And Gail Kodak contributed to the initial chapter, but unfortunately, for family reasons, had to withdraw from the project. So he's contributed something, but is not here. So Michele and I are kind of sharing the presentation, but we'd like to thank all the organisers and all of you for participating and making this such an exciting project to be part of. And I'd like to thank the other team members for their contributions. So enforcement is a huge topic, and it's one which I'm sure you'll appreciate there is relatively little research on, relatively little written about it for most jurisdictions. There are some jurisdictions where enforcement is a topic which is of a great academic interest, but largely not. So we've only been able to really scratch the surface of the subject, and I think I would really very much take to heart the comments that were made about comparison. So Deborah Hensler's comments about the fact that we bring to it our own understanding of how systems work. Enforcement spreads across court-based systems, administration, industry, professions. There are such different cultural things to bring to that, which Michele will talk about a bit more in a minute, that being able to get under the skin of the people who work in those different systems is really, well, impossible for us, but very difficult to do for any group of people. So these are the chapters that we ultimately have produced. The one on enforcement titles is my one that I haven't actually produced yet, but I hope will eventually form part of the project. And so we will be talking a little bit about these different chapters. In terms of emerging trends, I mean, this is the kind of baseline, and it's banal, really, isn't it, to say that trends in enforcement are about the tension between the rights of the creditor and the rights of the debtor, the right to effective enforcement as part of the fundamental right to judicial protection, but the need to protect the fundamental rights of the debtor. I know that's, as I say, that's a very obvious thing to say now, but I think it was, if we go back sort of 50 years, it was really fundamental to changing the way that people thought about enforcement and bringing enforcement into something which there was greater consciousness, and the sense that enforcement was, people had a right, creditors had a right to effective enforcement, which spurred on the trends in enforcement more generally. And at that point, I'll pass over to Michele to talk about some of the challenges.
Yes, we decided to have this sort of duet.
Yes, I'll try not to fall off the platform.
Oh, but don't fall yet. And we are trying to focus on emerging trends, and here I will quickly deal with challenges for enforcement. Enforcement can be seen as a sort of tug of war between the creditor and the debtor. Basically, the creditor looks for the assets, the debtor tries to keep the assets away from the creditor's hands. And here you can see a clear reflection of the connection between substance and procedure, of course, because the devices that are there to trace back assets are found, of course, in substantive law. So the law of enforcement can only come at the second time when hopefully some of these remedies have become effective. Today, the biggest challenge is probably this extreme dematerialization of wealth. Real money is no longer in buildings, no? But today, if you think of cryptocurrencies and you ask yourself, how do I attach cryptocurrencies? Yeah, this is something that I guess everybody will have to think about. And also the mobility of debtors and assets. Today, you know, with just a click, you move large wealth from one system to the other. And here is where the balance between creditor and debtor again comes to the fore through the possibility of having ex parte activities. This is a reflection of proportionality. I will talk about proportionality later. But the amount of activities, of enforcement activities that can be performed without the debtor being aware of them, of course, needs to be carefully considered. No? The need to have the surprise effect should not overcome some basic principles. And this third challenge that we have written on this slide, my chapter was titled Protection of the Debtor, which makes sense. But as you can see here, probably in today's perspective, at least certain categories of debtors are not thought of as to be protected like some wildlife animals, but more to be respected, especially because with the growing level of indebtedness, the global crisis, the recurrent global crisis, everyone can become a debtor. And this, irrespective of the fact that he or she doesn't want to pay. We can move to the other. Okay.
As other teams have said, we asked our team about the things that they would like to draw to your attention. And Alvaro particularly talked about the constitutional issues, and so was emphasised the constitutionality of protection of enforcement. And also, I think, an important factor, the rights involved in enforcement law are both procedural and substantive. So we've talked a lot about procedural laws, but a lot of the kind of issues that might arise in enforcement are concerned with substantive disputes. What happens after a judgment has been given in favour of the creditor and further actions and events take place? What impact does that have on the creditor's rights? Or at the point of enforcement, you may seize a particular asset and there may be a question about who actually owns that asset. So there are all kinds of substantive issues that arise in the course of enforcement proceedings. So there can be, and this is true much more in some legal systems than others, in some legal systems, there is a lot of satellite litigation around the kind of substantive rights as well as procedural issues relating to enforcement. And Alvaro was also stressing the importance of these minimum standards of protection of debtors' assets, but also debtors' dignity and personal data, the way that they have become embedded in legal systems around the world, and the important role of the courts that protect human rights in developing, again, protection for debtors in the context of enforcement.
As I was mentioning before, proportionality plays a big role in enforcement, just like in civil proceedings. But in enforcement, probably you see it from different perspective, and I would even say with more diverse facets. The general idea is that the harm for the debtor should be balanced with the benefit for the creditor, and this translates in certain legal system in the principle that enforcement should be performed in the least intrusive way. So this is something, I would say, an emerging trend, which is, I would say, an application of the proportionality principle. The idea that the rules should minimize the harms of the debtor involved. This might, for example, I'm thinking of an Italian example, translate into the striking out of enforcement proceedings when it is clear that the sale of the attached assets would be performed for such a small amount that it would be detrimental for the debtor. And at that point, the sale is simply struck out. Is this unfair for the creditor? Probably. Surely it would be unjust for the debtor to be deprived of an asset for such a small amount of money, just for the sake of it, one could say, because if the asset is so little worth in the balancing of the situation. As it was dealt with in the chapters, there should be a proportionality in remedies for failure to comply with a judgment. We have a chapter on the enforcement of non-pecuniary judgments, and there this principle at the substantial and at the procedural level is deeply analyzed. There should be no disproportionate coercive measures to induce performance. Alvaro and Woody deal with imprisonment for failure to pay debts. Is this disproportionate? One could say yes. So this is something we have considered and analyzed. And another facet of proportionality in this context probably is the flexibility of enforcement procedure. We've heard about flexible proceedings yesterday and especially today. This is true also in enforcement procedure. The idea that enforcement procedure should be adapted to the value of the debt in order to make them less intrusive for the debtor. Again, the proportionality principle. In the chapter on the protection of the debtor, Rudy and I have dealt with the limits to the attachment of goods, of assets. Every legal system has got some limits. They tend to have some central points with some variation, which are interesting, and I will go back to them a little later on. My take is that the limits to the attachment of assets is in itself an application of the proportionality principle. You can't take everything away from the debtor because this would be disproportionate. Two final facets of the proportionality principle in this context. More and more systems are encouraging the debtor to find a way out of the enforcement without the sale of the assets. In Italy, we have the conversion, while you basically substitute the attached asset in most legal systems, the attached asset with a sum of money. And this has been encouraged. And the final form, I would say, it's the limits to the duty to disclose assets. Whenever systems put this duty on the debtor directly, which might not be the best solution, as it's discussed in the papers, whenever this happens, usually the legal systems say that the duty to disclose is limited to the assets that would cover the amount of the debt. The debt, again, an application of the proportionality principle. I would move to the next slide to very quickly tackle the cultural, historical, ideological differences between the different systems. Of course, civil procedure is rooted in history, culture, and we have not discovered the wheel from this point of view. But it is interesting to see some reflection of these roots in how the systems deal with enforcement. Again, these attitudes are a reflection of the substantive remedies available in the different systems. So we can now talk about the possibility of having specific performance for violation of contractual obligation. This is clear. It varies from one system to the other, and of course, it's a reflection of historical and cultural and systematic approaches. Again, I was talking about the limits to attachments. The differences in the various systems are also a consequence of history and culture. I was amused to discover that in Switzerland, there is a limit to the livestock that you can attach. The number, the limits. So for example, a certain number of sheep should remain available to the farmer. It makes sense in an agricultural society. And also in North Macedonia, for example, we have limits that I haven't seen in other systems, and which refer to specific agricultural, rural economy. In Italy, we still have this provision in the civil code concerning, I don't know the name, the silkworms. and when you can attach them. Maybe 1940 to have a silkworm was a big deal. Today it's a little bit more exotic, so to speak, but still we have it. Still we have it. The limit to the eviction, this is dealt with in the specific chapter. This is a reflection of culture. An emerging trend in several countries, one could say first world countries, is the protection of pets from attachment. 30 years ago, nobody would think either of attaching a cat and of providing for the impossibility to attach the family cat, which today is felt like an important part of, I would say, the proportionality principle again. Yes, and I would say my final remark, and then I leave the floor to Wendy, is that the emerging trend is the diffusion, the spread of ADR in enforcement proceedings again, like in civil litigation in general. The idea that through the collaboration, the cooperation, of course, the forced cooperation of the debtor is induced to cooperate, but still you have more efficient enforcement. In Germany, the basic idea, from what I have gathered, that the enforcement agent should perform in the initial parts as a sort of mediator, stimulating voluntary last-minute compliance as a way to avoid enforcement. Again, proportionality. In Italy, we've just approved in a recent reform a provision which allows, we call it the private selling of an attached item. Basically, the item is still attached, but the debtor finds the buyer on the market. Of course, what is made out of the sale is taken by the court, by the enforcement agent, but still the idea is that the debtor has all the interest in making as more money from the sale as possible. Also the creditor, of course, but the debtor has the aspiration to get something, at least a portion back from the sale, which of course can become an illusion if the asset is sold for such a little price. So I think I finished.
Okay,
Sorry,
okay.
I took a lot of time.
That's okay. In terms of the enforcement institutions, which is my main area of research for anybody who knows me, again, historical and cultural differences are huge, and I'm not going to talk about the differences here, but you can read the chapter, as people say, or you can read my book. But there are systems which are, I say, based within courts that are administrative, ranging from, say, the Swedish system, which is regarded worldwide as one of the most effective and user-friendly systems. But you also find administrative systems in, say, Russia or Vietnam, which possibly don't function quite as efficiently. And then professionalization of enforcement in many parts, particularly again of Europe, using enforcement agents who are independent professionals is a major trend in the last 20 or 30 years. And in the UK, we talk about an enforcement industry rather than an enforcement profession. And all these systems have historical roots that go back centuries, which makes them very difficult to amend. So I just want to talk quickly about drivers of change and future challenges. Why? Enforcement is definitely an area where there's been a growth of interest. And one of the reasons for that, I would suggest, would be globalization, the movement of money, the desire for countries which are in competition with one another to attract investment. And therefore, they need to show that they can protect creditors' rights, and they need to show that they can provide secure assets. And so that has led to reforms of enforcement systems to make them more competitive globally. And one of the major things it's led to is information about debtors' assets. So as systems have modernized, that desire to have more information about debtors' assets has linked with digitalization. And there are many countries now where it's possible for an enforcement agent to get information from the tax office, from social insurance organizations, from banks in some countries, but other countries are much more reluctant to do that, from vehicle licensing organisations and so on. There is a large amount of information available. And so one of the questions that arises out of that, I would say, is what's the appropriate use of data? How does data protection mesh with the need for information about debtors' assets? Should that information be given to enforcement agents and not creditors? Should the information be passed on to creditors? Should it be shared also with organisations that are interested in giving advice to debtors? Because so my perspective on this is not so much the commercial end, which I appreciate is really, you know, is the money-making end and the end where the litigation takes place. But the vast majority of enforcement is against citizens who do not have these vast amounts of money to litigate their rights and obligations. And many of them are involved in debt restructuring. Should the information about the debtor's assets, which the debtor actually can't explain themselves, be given to debt advice organisations to help them to give advice? So there are some issues there. Cross-border collaboration remains extremely difficult, but with the movement of assets around the globe, then that's clearly an area where it's important that there should be developments. And competition between enforcement agents is also has the potential for corruption. I've put competition and corruption issues together. I'm not saying that competition necessarily leads to corruption or that corruption doesn't take place without competition. Big administrative organisations or court organisations can also have issues with corruption, but we're talking about an area of work which is all about handling money, and therefore the potential for corruption is huge, and the need to have close regulation of what takes place is huge. So there are lots of issues about the appropriate size, shape, funding and regulation of enforcement institutions, which, you know, I would say this, but they don't get enough attention. There's not enough research on what's going on and how things could be improved. And I just want very quickly to throw in a picture to try to explain some of what's going on in enforcement. So does this one do pointy bits?
I'm afraid 1 minute.
1 minute, yes, it's all right. So we start off with a block where you've got enforcement agents. I've got some little pale grey dots, which are the debtors. And you have enforcement agents who know about the debtors within their block. Okay, this is an ideal type. The real world's not quite like that. But historically, there was a certain extent to which that was true. Then you move on to introduction of competition and the increased size of the area with which enforcement agents work. So this is partly through privatised enforcement, but can also take place with, for example, the expansion of the judicial map and the areas within which enforcement agents are working, or in administrative spheres, which means that you've got more enforcement agents addressing the same debtors. And as well as competition between enforcement agents in relation to enforcement of judgments, it's important to bear in mind that if we look at the debtor perspective, they are also being faced by claims from the public sector. So whereas in relation to litigation, we're talking about individual parties, or in collective litigation, it goes beyond that, but a particular set of interests. Here, if you focus on the debtor is being approached by a whole range of different creditors from different public and private areas. And if you want to make sure that there's appropriate concern for the debtor's protection, and also in a financialised economy, helping the debtor to ameliorate their situation, to recover from their debt so that they can continue to participate in society, then that's an important factor to take into consideration. I'll jump over the third box. The fourth one is about coordination. And digitalisation has allowed a lot of coordination to take place. There are registers of debtors, registers of debts, registers of enforcement action. And so, again, a question for future development is, how should that be done? How should it be coordinated? Is it something we should welcome? How should it be regulated? What concerns should we have about data? Thank you very much.
Thank you very much indeed. Comparative enforcement procedures is a relatively new area of comparative procedural law. And I recall that I got in contact with Konstantin was Kerameus in Paris at the headquarters of the Union Internationale de Saisie de Justice, so the International Bailiffs Organization. And he was the first one who wrote in the famous volume 14 or 16 the chapter on comparative enforcement. This was really something new, and others stepped in when we met for the first time in Paris too. And when it came to the European bank account preservation order, Gilles was also in the expert group. It was very interesting to see that the experts there were very much in their national boxes. And this has changed now, and it's also changing now due to CPLJ. And I think this is a very interesting segment, part of our project, and opens up our perspective, especially when we go to the borderlines between enforcement and insolvency.
Yes, yeah.
And still we have also enforcement in real estate, which is again a total wide field of very interesting economic impacts. I'm afraid we do not have the time to take up many questions because we are running a little bit out of time. And so thank you again. We have to read it, we have to discuss it in the next
In private.
meeting. And now we go cross-border. Geneviève.
Wonder sit or stand. There should be one slide.
Yeah.
You can just the next one. It's on the next one.
And they can pull it down.
Up. Perfect. You can think sorry. Maybe I'll sit. Too many laptops on this.
Yeah.
So thank you. It's a real pleasure to be here. As I told some people, this is my last official academic presentation as a McGill law professor, because I'm changing institutions in a few weeks. And so I will remember this, particularly after 28 years. It's going to be a big change. And so I'm glad that it can be here, culminating in this great project. And of course, Burkhard is the hosting this session, but he's also a member of this group, and so it's a particular privilege to be sitting here with him. Some members of our team are here presently today. I see Gilles and Christophe. Louise Ellen was here, but she had to leave because she had an earlier flight. Here, Kalster and Philippe Dianpach are not here, but they have contributed their chapter. Marta Riquejo is still working on hers, and thank her for stepping in for replacing someone who did have to leave, and Justin Montenepo as well, who stepped in. So you have here the number of chapters. Most of them are on the website, and so be happy to get feedback afterwards when you've all had time to read them. So our section is called Cross-Border and International Dimensions. And so it's very different from all of the other sections. I think everybody probably thinks that, but ours is different in the sense that we are confronted with the actual diversity of procedural laws, because it's in the cross-border context that the clashes, the conflicts, or the incompatibilities are concretely, they come really to the fore. And so we had to also try to identify some issues that could be dealt with in a single part. We have almost all of private international law in one part, and that was a challenge. So really what we tried to focus on were the aspects of cross-border disputes that created obstacles, procedural obstacles. So in particular, focusing on obstacles for foreign plaintiffs seeking to institute proceedings abroad, obstacles for foreign defendants subject to proceedings in a jurisdiction that was not theirs, and aspects relating to taking of evidence abroad or application of foreign law. And so all of these things that, really involve having different procedural systems at play in a single dispute. Now, of course, the main point is that even though we're talking about cross-border disputes, we still have national procedural rules. And most legal systems don't have a special set of rules for cross-border disputes. Of course, there are pieces here and there, and Gilles' chapter on international jurisdiction, as you know, most systems will have rules about jurisdiction over cross-border disputes, but often those are piecemeal. And so there's really the attempt to apply rules for domestic disputes to disputes that have an international dimension. And Burkhardt likes to talk of international civil procedure, and I think that's helpful to say it's a different set of rules, but it also has the risk of misleading people to think that there are international sources, right, to these rules, sort of like private international law. The sources remain domestic. But at least in this field, and compared to other of the presentations that we've seen, there are some international sources. The Hague Convention on Private International Law has been an important source. Others have already mentioned the Service Convention. There's also the Taking Evidence Convention. There's the Choice of Court Convention. There's the judgments, the more recent Judgments Convention. There's the ongoing work on an attempt at a parallel proceedings convention. So there are quite a few international efforts towards unification. Of course, you have some regional ones. The most important that you all know is the European work. But still, the procedural rules are largely domestic. So in our part, we've tried not to try to cover everything, but to identify some specific areas that can cause friction in cross-border disputes and that have procedural sources. So I'll try to highlight one thing from each chapter. Of course, this is all very superficial. So in Burkhardt's chapter, he deals with the history and evolution, actors, factors, and debates, talked about drivers as well. And it's really a fascinating look at what has happened over the past 50 years in particular to show the vibrancy of this sector that has known enormous change over the past decades. And of course, Europe has been a very important driver here because of the efforts at harmonization, unification, but also as other segments have noted, the rising importance of constitutionalization and fundamental rights, the drive to non-discrimination in procedural law, of course, affect cross-border disputes in a specific way, and digitalization as well, right, is going to have a significant impact. So that chapter is very key. It's almost like the introductory chapter to the rest. In my chapter, where I look more at obstacles for foreign plaintiffs, one thing that I found particularly interesting was to study security for costs, right? So the possibility that the foreign plaintiff could have this additional burden of depositing a sum of money just in order to undertake proceedings. And historically, that was a very common obstacle, but more and more it's been rejected as being a discriminatory treatment of foreign plaintiffs. And that's not across the board, but it seems, I think, the consensus is, and you see that in international instruments, the Hague 1980 Access to Justice Convention, in the Brussels move, many soft law or hard law instruments in Latin America, the Las Leñas Protocol in 1992. So the consensus seems to be that imposing security on the sole basis of the foreign domicile or nationality of the plaintiff is not an acceptable position to take procedurally. But of course, as always, there are some outliers and some exceptions. But it's very interesting to see this evolution of the importance accorded to non-discrimination that comes really from public law and fundamental rights translate into a very specific procedural law rule. In terms to international jurisdiction, so there it's also an access issue, but it's more specifically looking at how has that changed, making courts more open to receiving foreign plaintiffs, but also accepting that their parties could be sued abroad. So there's a clear connection with the section on foreign judgments. And here, this is Jacques Garci's chapter, and he shows the real significant, I think, expansion of acceptable jurisdictional bases. So reducing the obstacles to jurisdiction in cross-border disputes, sort of a reduction of exorbitant jurisdictional bases linked to nationality, for example, the reduction of exclusive jurisdictional bases as well. So there, this chapter shows the increased, I would say, enlargement of jurisdiction, but still with the quite notable cleavage between the typical civil law approach, which is fixed, predetermined rules of jurisdiction, compared to the largely common law approach, which is much more discretionary with the forum non-convenience. But even there, we know there are some points of overlap, and so that's going to be something to look to in the future. And of course, when you're talking about cross-border disputes, you also have concerns for the foreign defendants who could be called in to defend, and that often raises issues of service of process across borders, since the defendant is a foreign defendant, and that's a large part of the chapter that Geert van Koster and Philippe Diendrage produced in section 5, and there you have lots of work done from the Hague Service Convention, but as mentioned, it's an old one, and here digitalization, we expect, will both facilitate communication across border, but also perhaps raise concerns about fairness, what qualifies as notice. In Canada, they've allowed Facebook notifications. There are a lot, of course, of problems with that. This chapter also deals with the right to be heard and raises questions, for example, about understanding the claim that's made against you and being in a position to respond with evidence, for example, in a different language. And here, again, digitization can be very powerful. You have very good translation tools. I'm sure you've all used them. I use them. But that also carries with it some risks. But it certainly seems to be a positive development, increasing allowance of use of different languages before some courts. Fortunately, it's often just English, but still you have perhaps a reduction in that sphere. The foreign law and evidence is a bit of a, perhaps looks different, but here again, you have questions about what does it mean to obtain evidence in a foreign country. Here we have the Hague Convention. This is Louise Ellen's chapter, and there's lots of jurisprudence in the US about how can we take advantage if you're outside of the US with the great procedures of discovery that are available under US laws. Here you have a real conflict between very generous evidence gathering techniques and ones that are much more limited. And here you have the possibility of trying to take advantage of a more open access through recourse to taking evidence. And it seems that the US courts remain quite open to allowing that. So that's maybe one of the good parts of American discovery, is if other parties can take advantage of it, as long as you have a connection, right, to the US. Enforcement of foreign judgments, of course, we all know the importance of that. The previous section on enforcement tells us how it's key to enforcing rights is to be able to enforce the judgment in the cross-border context. For a long time, that was very difficult, it was very limited. But this, again, is an area that has really expanded, much more openness to giving effect to foreign judgments, but still with some countries that insist on either treaty relations or formal or informal reciprocity. Here we have a quite recent instrument from the Hague Conference, the 2019 Judgments Convention. It has now 30 member states, including the UK that just ratified a few weeks ago. Of course, we know that was for political more than legal reasons, but still the EU, Uruguay, Ukraine. So still, it's not as many as the New York Convention on Foreign Arbitral Awards, but that nobody can ever compare. but it's moving in that direction. So there's a trend for greater cross-border enforcement of judgments, which is seen as feeding more access to at least dispute resolution, perhaps not necessarily justice. And finally, the cross-border coordination and cooperation, which perhaps is a title that hides a lot of the substance. And this is Christophe and Maciej's chapter that deals a lot with some other issues that have been mentioned. So provisional measures, and here the challenge between very different types of provisional measures in different jurisdictions. And if you have a cross-border dispute, you'll have one party seeking a provisional measure in one jurisdiction and the other one seeking another, or anti-suit injunctions, freezing orders in extraterritorially. So you can immediately see the clash, and in the absence of some uniform approach, how are courts and parties meant to deal with that. And also parallel proceedings and questions of lis pendens and res judicata. So there's a very rich comparative analysis of these questions in chapter 8, which finishes with judicial cooperation, which, again, did anybody else talk about judicial cooperation? I think yesterday at the beginning, but maybe I've already forgotten it, but it certainly is an important development in procedural law cross-border, right? The possibility that courts actually try to coordinate cross-border disputes. It happens in some areas, so child abduction under the Hague Convention, that's a very big part. You know, in insolvency, which I know is not in ours, right? There is some mechanisms, but a general approach to judicial cooperation in cross-border disputes on procedural matters is a new possibility. That chapter discusses existing ones. There's a movement in the Hague Conference on Private International Law to try to develop that as a solution for parallel proceedings. I've seen the interim product. It seems more complicated than a solution. And there's big questions about legitimacy, about fair process. The parties are not involved when the judges are speaking to each other. And so transparency are going to be very big hurdles to overcome to make judicial cooperation a solution to challenges in the procedural context of cross-border disputes. But it's a promising, let's say, type of mechanism, and some successes in the past suggest that it could be developed further. So what are the next 50 years to look like? That's a crystal ball. I dare say most of us won't be here to see what has happened, but it does seem that there's a lot of movement ahead. The revolution of digitalization, I think, in the cross-border dispute will have a big role to play. Enhanced communication, disappearance of geographical distances as an obstacle, increased access to foreign law and foreign procedures, even just through translation, but also many more jurisdictions now have open access legislation and case databases. So that, I think, should reduce some of the existing obstacles to procedural cross-border issues. But of course, there's still a lot of uncertainty about this digital evolution, and whether or not it leads to more procedural justice, I think, is an open question. So
let's hope for it.
Let's hope for it. So that's it. Thank you.
Thank you very much for this round trip through the whole segment. And I would say maybe one or two questions, short ones, should be possible to be asked.
And I told my team members who are here that if it's a question about their section, that they are most welcome to answer.
So the floor is open.
People are getting tired.
If there are no additional questions, I would say we move on and we invite everybody in the room to read.
Yes, indeed. Thank you so much for that.
Thank you. And now I ask Philip Steffek to join. So we have one segment on consensual dispute resolution and arbitration. It has evolved a little bit because initially we had two segments.
It's just the next
It has merged for the moment, and it might, in the next edition, change again. And Felix Scheffek will give us an idea of what we can find in this part of CPLJ. You have the floor.
Yeah, thank you very much, Burkhard, for assigning us the last spot in today's presentation. You know, in the one before Geneviève presented, I thought you were doing so well. Everyone was concentrating, asking questions, and now I'm a bit worried because there were no questions. But I'll do my best to make this last part as interesting as I possibly can. And I think it actually is really interesting because it's a bit different. So we are a bit of an outlier, perhaps, having been initially, charged with the question, why not go to court at all? And perhaps then we modify that a bit in the course of the project. Now, I've got the pleasure to present other people's slides. And the reason is that for various reasons, they can't be here. So I'm alone fighting for my group. It was reasons such as that Remo's flight was rescheduled and he greets you all from the airport. Now, what are the issues that we deal with? So Antonio Cabral starts with a chapter on, giving an overview and then focusing on online dispute resolution. Then Remo really, really digs deep into history and thought and asks who is human, or who is the human, and why does that matter for dispute resolution, and how should we look at dispute resolution considering human nature? And he is an optimist, as you will see. Then what I'm trying to do is establish a taxonomy of dispute resolution mechanisms and regulatory tools or regulatory strategies that lawmakers use to help people solve their problems. Helena Soleto then adds a chapter on institutionalizing consensual methods in the judicial system. So here we're kind of starting to interact with the judicial system in particular, and the same is done by Shala Ali, who looks at, in particular, voluntary and mandatory mediation programs in court. We end my presentation with a look at comparative mediation law, and that is a chapter contributed by Nadia Alessandro. Now, starting with Antonio Cabral's contribution, so he first gives an overview over the particular types of ADR, and in particular, the ones that he deals with are negotiation, mediation, conciliation, and others such as dispute boards and collaborative law. He then focuses on online dispute resolution and rethinks that, asking, do we need a new theoretical background? What are the types of ODRs? Do we need new skills? And so he in particular is interested in dispute design against the background of ODR. The incentives that can be put in place, and on the other hand, the procedural safeguards. Now then comes Remo Capone's chapter. He asks, he is homo, and shows his optimism that he contradicts those who think that, or who have a negative view of humans. So he goes into history of thought, interacts with Hobbes, arguing against the idea that the man and the woman and others are the wolf against others. So he has a more optimist view, and he argues that people are actually in development, so they create themselves. They are the not yet determined animal, referring to thoughts by Nietzsche and Galen, and that is what he says we should base dispute resolution on, and in particular, consensual dispute resolution. Now then he, looks at the entire history of humankind and argues that actually the forms of dispute resolution that we find are rather new. And they are, so he argues that these are recent phenomena. And looking at the fact that consensual dispute resolution and other dispute resolution mechanisms are so recent, then he projects that we will see major change in the future. In particular, he argues that it is capital and technology that are currently driving the development of dispute resolution. And if that is true, he argues, then actually it is that state institutions are losing relevance because it is the more privates, using capital, using technology, solving their disputes. And so he develops his further thought on the possible marginalization of state institutions in dispute resolution processes. Against that background, he interacts, in particular, I think, with the editors who first asked the group to ask the question, do courts really matter? Arguing a bit against that, perhaps, taking the point that it is actually the interests and needs of humans that matter. And from that perspective, he's in particular interested in two questions. That is, how far should the animal violence or perhaps the negativity that may be part of the human character be part of the design of dispute resolution processes? And secondly, how can we use conflicts to keep innovating the structures of dispute resolution mechanisms and institutions? Now then, I'm adding my chapter in which I'm focusing on dispute resolution mechanisms and their regulation. And I think this chapter is developed on the background of my experience that when we talk about dispute resolution mechanisms, in particular in ADR, then there are so many. And the question is a bit how we get a grip on those, both in terms of understanding them, analyzing them, but also in terms of regulating them. And I think that having a taxonomy that firmly has a strong functional grasp on both the mechanisms and the legal strategies that legislators use helps us in that process, then ultimately culminating in ideas on how we can regulate them. And so I've already shown this in the midterm conference, this slide, but I think it held up. And here the key of this taxonomy that looks at dispute resolution mechanisms is one of function and one of human centricity. So instead of defining mechanisms via their perhaps objective characteristics, I'm asking, how do they affect people? And here, looking in the second line, you see that I think dispute resolution mechanisms affect people in terms of, can I initiate this or can I be forced into this? So this is initiation control. Do I have a say on the process, or am I exposed to a process that others define? That's procedure control. Do I have a say on the content, on the outcome of this? That's result content control. And whether this content is binding for me or not, that is result effect control. Then also, can I choose the person that helps me solve my conflict? That is neutral choice control. And do I have control over whether information leaks out or whether it stays private? That's information control. Now, if you apply this in a yes-no logic to core dispute resolution mechanisms, then you get a taxonomy, a matrix that helps us regulate or analyze these processes. Now then comes the tricky bit, and that is, I hope, innovative and interesting. That is to think about a taxonomy of regulatory strategies that lawmakers use in designing these dispute resolution mechanisms, but also that private parties use in contracts, for example, to pre-plan dispute resolution. And so I identify a list of regulatory strategies. They are collaboration, representation, so I'm represented in my dispute, delegation, I can delegate decisions to someone, collectivization, meaning that sometimes I can't act alone, or I'm represented by others that represent a collective. Regulators and contracts assign decision rights. That is, they allow initiatives and they allow veto. They assign constraints. They disallow doing something and then they impose liability if I still do it. They create incentives, stakes and rewards. They create entitlements, which is a very strong form of regulation, and both in terms of public and private ordering, where rights are assigned. Then legal institutions, in terms of their design and applicable law, are created and determined. And finally, there's an information strategy. And I think that, or I would argue that these legal strategies give us a firm hold on then comparing legal dispute resolution, or legal and non-legal dispute resolution, and also in terms of designing it. Then the chapter ends with some regulatory approaches. I'll keep that short, but perhaps, kind of just to mention that if we draw from other areas of law, then there is certainly no one size fits all. So I think the challenge of dispute resolution mechanisms and their design is allowing people to fit the problem to their mechanisms, but also within mechanisms have some flexibility. Now, moving on to Helena Soleto's chapter, she looks at institutionalizing consensual methods in the judicial system. So here, kind of the group starts interacting or engaging with the judicial system. I hope you still understand me. Should I wait?
You don't recognize it.
Contact that people are outside of the sexual just so maybe there's not a fire, but maybe sorry.
This is not So, ladies and gentlemen. Please continue.
Yeah, thank you very much. So the good news of all of this is that I will just deduct that time from my presentation. So I hope that helps. So the next chapter offered by Helena Soleto looks at the institutionalization of consensual methods within the judicial system. And so she kind of looks at the interplay between litigation and consensual dispute resolution in terms of referral and the procedural impact, such as lack of jurisdiction, suspension, provisional remedies, and enforcement. Shala Ali then looks at, in particular, mandated and voluntary court mediation programs. And here it's quite interesting that her, in particular, comparative outlook identifies really interesting aspects. In particular, for collective-oriented societies, she identifies a more positive expectation of human behavior, leading to an expectation that humans can solve their conflicts in a non-adversarial way because they are interested in the collective. However, she also thinks that in such societies, the approach that is a more normative, a more determinative way of non-court dispute resolution can lead to the neutrals forcing their opinions on parties, which ultimately undermines that process for the stakeholders. She then looks at comparatively at jurisdictions and identifies that there are some jurisdictions that actually do see consensual dispute resolution not as the alternative, but as the mainstay. And from that perspective, then the question is how individual rights are protected and choice is prioritized. She adds in particular then a focus on voluntary and mandated dispute resolution or ADR dispute resolution in terms of benefits, challenges, and implications. And then the final chapter provided by Nadia Alexander looks at mediation in particular. And she takes a comparative perspective and she makes the bold claim and says, actually, mediation is the dispute resolution mechanism that grows the fastest. And one of her arguments is the Singapore Convention on Mediation. She's in particular interested in developing a systematic approach to mediation law, arguing quite similar as I do in my chapter that we need still frameworks to actually shape the debate. And she offers the mediation matrix, in which she identifies 4 aspects of mediation that can be subject to regulation, and then 5 types of regulation that are commonly used. And here you have a view of that mediation regulation matrix. The regulatory form is marketplace or private contract, institutional or industry regulation, court regulation, case law and general legal principles, and legislation. And the regulatory content is triggering, process, accreditation and practice standards, and rights and obligations. And ultimately, she argues that it is a regulatory matrix that works best. So not kind of a one-size-fits-all again, but instead taking the aspects of the regulatory approaches that work best for the issues to be regulated. Now, with this, I end. Burkhard, I think we are a bit behind time, so I'm not sure whether we'll have questions and comments or whether you want to move on to the next group already.
I'm afraid it's a little difficult, but I all invite you to read this part. It's really very interesting, and I would like to invite Jose to give a short outlook of the arbitration chapter he has authored and
Well, thanks. First of all, I would like to thank the organizers, Margaret, Enrique, Burkhard, for the invitation to take part in such an interesting researcher task, which I certainly enjoy very much.
When you raise your voice a little bit.
Okay. When the task was organized by Janet Walker, our coordinator, she has assigned me the topic of independence, impartiality, and neutrality of the arbitrator. Therefore, my work, which I will try to synthesize for your information, includes an introduction pointing out the main particularities of arbitration in respect to those generally called as alternative dispute resolution methods, as I have made a distinction between those that are not adversarial and those such arbitration that are as they require a decision market, who is in this case is chosen by the parties, so that be means of a final decision of settled nature, may award the rights involved in the conflict to the person who, through the evidence produced, can prove it. Then I try to differentiate what usually overlaps, which are the basic aspects of what should be understood by independence, impartiality, and neutrality. While independence is to be analyzed objectively by the relation that the arbitrator might have with the parties, impartiality is analyzed from a subjective point of view and, of course, much more carefully. Thus, it refers to the biases that the arbitrator might have either with the parties or with the subject matter of the dispute. In turn, neutrality usually overlaps with impartiality, as it has borderline contours with that concept, although in general it is usually analyzed in international arbitration, tending that the arbitrator to be appointed belong to a country other than that of the parties, an aspect that is specifically contemplated by arbitrator rules, as in the case of the ICC, for example. As this rest aspect are part of the development of the due process of law, I pointed out the importance of nothing, that they are fundamental principles to be observed of its development under penalty of carrying out a void process. This led me to distinguish the fundamental principles of the various systems that exist, pointing out that the latter are represented by the form adopted by the parties or an institution that provides arbitration service to structure the process. And in turn, all this was accompanied by cost law that came in support of those aspects that make the essence of the work and allow to demonstrate how these fundamental principles impact in the usual practice for development of a due process of law. Thank you very much.
Thank you very much. Let me add one word here. We had this segment on arbitration foreseen. It is always a journey to start and to develop such a big project. And my idea is to have your chapter, which is very important for the moment in the segment on alternative dispute resolution, as arbitration is in a larger sense also private dispute resolution and an alternative to state courts. But we will certainly take up arbitration again and to build up the segment, and then you will be part of a nice conference, something like this. I'm intending to organize in almost 1 or 2 years time. Now I'm already a little bit in the last part, the perspective of the project, and I would like to ask the co-editors to join me for the last session. And I think the first point to be addressed now is a message we received from Loic Cardier. Loic, you could not come, but you are with us online, and you sent a letter, and Margaret kindly agreed to read it to all of us.
That's right. So, dear colleagues and friends, first of all, let me express my apologies for not being among you during this final conference. Of course, because of COVID, the CPLJ successfully experimented online debates with its webinars. And since yesterday, I attended the conference online for the same reason. He was diagnosed with COVID. But as you know, nothing replaces the warmth and the richness of human contact, especially when the microphones are silent and everyone gets together around a cup of coffee or during a meal. To these apologies, I must add thanks, immense thanks, in addition to those that Burkhard and Margaret have already addressed, to all those without whom this incredible adventure would not have been possible. The editors, the contributors, the administrative and technical staff, and of course, Severine, who has taken in charge of the organization of this final conference. Above all, allow me to express my deep gratitude to the one who took the initiative for this project and who carried it through to the end, despite all the obstacles such as the life event and the stupidity or jealousy of certain people had left on his way. So thank you, Burkhard, for your visionary. As Sabrina said yesterday, and for your total dedication to this project. And thank you for associating me with a part which turned out to be very modest compared to that of Margaret and Irene. Through me, it is the International Association of Procedural Law, which was associated with this unique and unprecedented enterprise, which seems to me to go well beyond the considerable contribution that Volume 16 of the International Encyclopedia Comparative Law had already made under the direction of Mauro Cappelletti. In a way, the IHL conferences and summer universities like a hyphen have made it possible to keep the flame of comparative research in civil procedure alive under the renewed leadership of Eduardo Oteiza since 2019. But CPLJ goes internally Mario Cappelletti's initiative due to the number of his authors, true, the scope of his subject, his collaborative methodology, the interdisciplinary nature of his approach, and its open access publication support, which leaves open the possibility of permanent updating, and we will discuss this later. And between these two beacons, however, everyone will be able to measure the distance traveled, the lines of evolution of national civil procedure, the evolution of their respective relations in a complex world where the globalization of economic relations can compete with the fracture of political spaces. And civil procedure is not just a formalistic technique for the judicial settlement of civil disputes. It is more fundamentally the space for restoring social relationships, the regulated substitute for violence in which civil procedure participates in democracy as a public space for dialogue before what John Perrone calls the universal audience. There will therefore be two ways of reading this international opus of civil procedure. In a technical register, the reader will be interested in micro questions of procedural engineering, such as, for example, that of the structure of the procedure or that of access to information. But in a more political register, his attention will be drawn to macro questions of procedural philosophy, such as that of the constitutionalization or fundamentalization of civil procedure or the digitization of civil procedure. But of course, the partition is not watertight between the political and the technical. It is rare that a technical question does not have a political dimension and vice versa. Just remember yesterday, Rick's presentation. Just think also of the conditions for granting legal aid or of the condition for granting a final appeal. Finally, it will be interesting and necessary for carrying out a transversal reading of the different chapters of this opus for two reasons, at least. First, to review the major trends on an international scale and the contemporary evolution of civil procedure. For example, the tendency towards managerization, contractualization, digitalization of procedures for settling civil disputes, their forms, their domain, and their limits. Secondly, what these development implied both with regard to judicial organization, respective places of the single judge and the collegiate court of the first instance and appeals, articulation between judges and mediators, et cetera, and with regards to the design of procedure, ordinary, special, forms of litigation, general and neutral procedures, or procedural rules serving the matter of the dispute, if there's online proceedings or not. These are all questions of ready-to-wear justice or tailor-made justice. Much has been done by the authors, but much remains to be done by the readers. The CPLJ project must definitely be a collaborative work in progress. So thank you to all. Louis Cartier. So it's actually a terrific way of really talking about how this project could be used and how this project could be kept alive. Louis already gave you some ideas about, how we can approach reading this project, but we could also open it up for discussion. You have some thoughts, I have some thoughts, but about future steps. So I'll leave it to you to open.
Maybe I open with some technical ideas. We are now closing the final conference in a couple of minutes, but we are all aware that the web page, the website, has not been totally uploaded. So we will continue editing manuscripts we have already received, we are receiving until the fall of this year, maybe even a little longer. But I will be very frank to you, this is not a prolongation of time limits, I'm afraid. We need some time to edit. We are a very small team, and it's now running from Vienna. We had great support from Luxembourg, from Boston, but it's also a question of funding, and funding comes to an end because the Fonds National de la Recherche is seeking a final report from us October the latest. And if I get in November a manuscript, it will not be in the final report, just to be very frank, and they will really look at what we have promised and what we have delivered. So therefore, please come up with your parts as far as they have not yet arrived. Many have already arrived, and what we have seen and what we have heard during the last 2 days is really very, very much, it's, let's say, put it that way, it's impressive. It's really impressive that we were able to make this enterprise. And we will also work on the possibility to have print on demand from the web page. This is something I cannot promise to you, I have to negotiate, but I will do. We have not started negotiating because we wanted first to have something to be shown, and then you can negotiate. But I'm already in contact with some people. And then the big question, of course, is not, let's say, the finalization of the step here. This we will do, this will be achieved. But the question how to continue such a project. And as I said, if you put something online today, the idea is always that there will be some updates, and updating is, of course, also keeping the project vivid, living. The platform shall be a major source of reference. Maybe it can even become more a means of communication. We, as co-editors, will continue, not every week on Zoom, but we might also invite the participants to look at their segments, at their chapters in a certain moment of time or after a certain development we are aware. We will certainly not call the digitalization team every week. But these are also very interesting developments. I'm pretty sure that CPLJ will serve as a basis for additional discussions. There is the IAPL as our organization, which was already backing the whole project. I talked with Eduardo Tesa about this several times, last time a couple of minutes ago, how to continue. One idea is to have CPLJ as a topic at the World Congress in Vienna in 27. And it might be good to look back a little bit, to ask what are our experiences, also with some temporal distance. And I would also like to look forward in the sense to ask colleagues, especially young colleagues, what they do expect from such a web page, from such a platform, whether we should progress in additional different directions. So I think this might be the next date. We also might, but this is something to be decided by the IATL, establish a kind of working group dealing with CPLJ to give a certain institutional framework. But as far as we have progressed, I would say, let's continue. It's really worth doing it.
So just let me say a couple of words before we open it up. I kind of feel like our job as editors really is to ensure that your hard work gets recognized and gets used. Mm-hmm. And so I've been spending we've been spending a lot of time thinking about how to make this kind of open access materials usable. And there are specific individual steps, immediate steps, and then there are long-term steps. So in terms of immediate steps, actually, I would request that you think about your chapter and think about keywords and an abstract. And I just finished editing another book, and that really is the best way for search engines to be able to locate your particular chapter. So in fact, we are going to come back to you for these specific kind of requests. So the project isn't totally done that way. And the other thing really is to increase the use of this is as you're reading it, a little bit to back what Deborah Hensler said. Yeah, I know the US, but I don't know, even if I read 100 articles, the other legal systems. So when I'm reading some of these pieces, when I recognize something that could be corrected or adjusted or clarified in the US area, I would contact the author, and I would urge all of you also to do that, to ensure the integrity of each other's works. And I would think you would want to read these chapters because they're interesting. They truly are. Each one of these chapters can be a book in itself. So that would be the other request. So we might come back to you for like keywords and abstract, you read each other's, and also within your chapter to be able, as you're finalizing, to link to other chapters. That's another way by which we can make sure that each other's work get recognized. So that would be the final request I would make in terms of making sure that this piece also stands as a whole. And then, of course, the future step is, Burke has said, it would be terrific to take it up with the IAPL, to have it as being kind of a institutional collaboration. And really, if we can make a commitment that this, since it's online anyways, you've done 90% of the work, if you've already got your chapter. To update it would only require, maybe a research assistant to go out there and to do it. I foresee every 2 years to have another edition, and to have CPLJ, this is the first edition, and then 2 years later, a second edition, and then 2 years later, a third edition. Because if it is updated, again, it will continue to be used. We know a lot of the print version we no longer use because they're quite dated. But we have the ability, since we've opted for this open access, to have really periodic updates, a relatively easy manner. And so that would be my other thoughts in terms of future steps, immediate steps, future steps. But we can certainly open it up both to Severa and Enrique if you have other thoughts about how we can continue this, to make this, to highly publicize your work is what we like to do. Thoughts?
Now, just a word talking about advertisement and publicity. I think it's very important also that the CPLG website is known all over the world. So please use your social media, your university webmail just to circulate the CPLJ.org website.
And on my side, a very maybe emotional appeal, which is the notion of spirit. Is there a CPLJ spirit maybe? And I was very touched when we had the kickoff conference, the online kickoff conference at the beginning of the pandemic, by something that Tom Main said. He's no longer with us, he had to step down. But I just wanted to read it to you in case it helps us to continue and to keep it alive. And this is, Tom said in 2021, I predict that the greatest legacy of this project might not even be whatever heroic multi-volume corpus we are undertaking so deliberately and thoughtfully, but rather the greatest legacy might be the joint projects and collaborations and friendships in the decades to come that could be traced as starting with relationships that were formed here in CPLJ. So if we take advantage of this spirit, maybe we could be able to make it. Thank you.
Thank you. So,
I think it's a moment to close the final conference.
okay. All right.
And I have to thank many people. First of all of you, for your participation, for your commitment, for the spirit. And then I have to thank specifically to some persons. First, I would like to start with the Luxembourg Center for European Law, Pierre-Henri Connac, who really took it up and supported the project and made it possible that we could meet in this room where we had met before several times. And especially Severin, what you did was really amazing, because when we had the institute, we had a team preparing conferences of this size. You did it with your Severin Mariani.
It's my team.
And it is really incredible what you have done. And you even did more. Yeah, you stayed a little longer in Luxembourg to make this conference, this project possible. So thanks a lot. This was really. And I would also like to thank the Vienna team, Marcel, Elena. So what you did is also, and you are doing is also terrific, I have to say. Sometimes I approach the computer where you are sitting and editing texts, and I'm asking, where are you now? And then they turn around and say, I'm now, let's put it neutral one, in Cabral. It's so good, so interesting. And this is also a little bit the spirit we are in, and we should continue that way. Pierre-Henri, you came a little late. You missed my expression of gratitude for your support of our project. And finally, I have to thank the co-editors of this project. Of course, the coordinator, the teams, but you are already here in the room. But I think we really experienced together with Loic, and we really do miss you, Loic. But there will be a next meeting. That's a good thing. Here in Luxembourg, but we had a project over 5 years with a lot of engagement, but also a lot of fun. And let's continue in that way. Margaret, especially you, of course, fantastic. But
fun.
we all.
Yeah.
So thanks a lot.
Thank you.